Good morning.
Morning.
And welcome to the February 18th Victim Compensation and Government Claims Board meeting. Would you please call the roll?
Chairperson Fisher.
Here?
Board Member Michael Ramos.
Here.
Board Member Richards.
Here.
Thank you. All right. Would everyone please join me in the Pledge of Allegiance? I pledge of allegiance to the flag, to the United States of America, and to the republic for which it stands,
One
nation, under God, indivisible, with liberty and justice for all. Okay, thank you. The first item is item 1, the approval of the minutes of the January 21st board meeting. I was not in attendance of that meeting. However, I spoke with my general counsel, Holly Pearson, who was acting chairperson at the meeting, and she reviewed the minutes and allowed me to be her proxy. Are there any additions or corrections to the minutes?
No. Move approval.
It has been moved and seconded to approve the minutes of the January 21st board meeting. Any discussion? Okay, seeing none. All in favor?
Aye.
Aye, thank you. Okay, item number 2 is the public comment period, but this is the opportunity for the public to comment on items that are not on the agenda. If you'd like to make a public comment, I would like to invite you to come forward, state your name and title for the record. Okay, seeing none. I'm going to move item number 3, which is the executive officer's report, to back in the agenda. We have a little bit of a time constraint this morning. Commissioner Ramos has a conflict and has to get back to the duties of his district attorney's office.
Yeah,
And I also have something pressing me at the noon hour. So we're going to jigger this agenda a bit. So item 3 will come at the end of the agenda. You're okay with that, Julie? And Nicholas, we're going to move item 4, the consent agenda, down, along with item 5, item 6, item 7, and we're going to take up item 8, which is the claim of Luis Galicia. Item 8, the Penal Code Section 4900, claim of Luis Galicia, that will be presented by Chief Counsel Wayne Strumpfer.
Thank you, Chairman. This claim,
Does anybody need to come forward at this time?
yes, if the parties can come forward. It's John T. Richards and the claimant. For the AG's office is Heather Gimley and Lorinda Delaney.
After Wayne gets done with his presentation, I'll have you introduce yourselves, but we'll wait until he's done with his presentation. Thank you.
Claimant was convicted of 2 counts of sexual assault and sentenced to concurrent 15 years to life sentences. Less than 3 years later, claimant's habeas corpus was granted by the San Diego Superior Court, and he was released. Claimant served 1,068 days in prison. Staff's proposed decision is to approve the claim and recommend the matter to the legislature for payment.
Okay, thank you, Wayne. Now, I would like the claimant's counsel, claimant to introduce themselves, and then we'll turn to the Attorney General to introduce. This is just introductions. You'll start your presentation afterwards.
Thank you very much. John Richards here, along with my client, Luis Galicia, who's sitting to my right.
Okay, thank you.
Lorinda Delaney from the Attorney General's office.
Heather Gimley from the Attorney General.
Thank you. Okay, would you like to present?
Thank you very much, Chairperson. Shall I remain seated when we do this? I'm a little bit of a fish out of water. I haven't presented
Yes,
a claim
yes,
here
you may.
before. Thank you very much. We have a claim before the board for 1,068 days that Mr. Galicia spent incarcerated. I would add that 5 months of that time was spent in administrative segregation, where he was locked up 23 hours a day. The facts of the case are essentially that he was convicted based upon a medical report that was later debunked by the district attorney's own expert sexual assault team in downtown San Diego. While he was serving his time in prison, his sister had been taken by Child Protective Services. She had immediately recanted the allegations several months after being taken into custody of Child Protective Services, but wasn't returned home for several years. When she finally came home, her mother took her to 3 separate doctors who performed an examination, all of which were contrary to the original findings of the doctor who testified on behalf of the prosecution. Those 3 doctors led to the district attorney allowing a new examination with their expert team at Children's Rady, which they confirmed, in fact, that the original report that convicted Mr. Galicia was, in fact, inaccurate. I would add, and not included in the report, is the fact that there were 10 other cases, all involving the same expert witness that testified against Luis Galicia, that were all sent for review at the same time, and they were all found to also be inaccurate. Those cases.
And that expert witness was who?
Dr. Mary Spencer was that expert witness in San Diego. So it wasn't as if his case was in a vacuum at that period of time. It was part of a larger review of this expert that they had been using repetitively to determine whether or not there were positive findings of sexual assault in children. The sister who made the allegations, I can go into all the details, but it would be probably better spent to just say she was very confused. She was attempting to date an 18-year-old gang member. Her older brother, Luis, stopped that relationship. She got very angry at him for doing so, tried to run away from home, and when she was caught running away from home, made the allegation of the sexual abuse against him. She recanted that again within 2 months, and at trial also testified that there was no sexual conduct at all. So in the end, when Mr. Galicia was released, it was done unopposed by the district attorney's office. It was stipulated by the attorney general's office. The habeas petition was filed 3 days later. The unopposed paperwork was pushed through, so there was no opposition to the appeal. And what I'd like to show the board is essentially a clip of the story that was presented to the San Diego community through Univision. It was a very large story in the Latino community about this wrongful conviction. There's a few points of the video I'd like to bring to the board's attention. It is in Spanish, however, it does show the actual release of Luis. It shows the sister apologizing to him and him accepting that apology. And more importantly, it shows District Attorney Bonnie Dumanis giving an interview of which she says that this is the right thing to do, that she's personally reviewed the evidence and feels that Luis Galicia should be, in fact, released from prison.
Is the entire video in Spanish?
The entire video is, except for the interviews with the district attorney, it's only a 4-minute clip. So it's the newscaster's version of the story is in Spanish, but I think the board will get the gist of some of the footage that's available to see. So this wasn't a technical release where there was some technicality. This was a release where everyone was in complete agreement at the end that Luis Galicia should be released from prison. There was no doubt that this report that convicted of him was a inaccurate report, to understate it, I guess, a little bit. So with that, if I can play the video for the board, or can I take any
I
questions?
have a
Feliz,
question.
finalmente se cierra.
Can you hold the video 1 second? Thank you.
Yes, sir.
What was the time period between the examination of the sister? What was the time frame when the mother took the sister for examination from the time of this said incident?
There's reference to the mother taking the daughter for an examination in Mexico. Is that what the chairperson is referring to?
The one you referred to in your presentation. You referred to an examination in your remarks.
So those examinations occurred after the release of Araceli from custody of CPS. I want to say that was mid-2009 to late 2009 when she first saw the 3 pediatricians and gynecologists that while the district attorney didn't utilize them as the basis for the relief. They opened the door to having the district attorney have their own experts come in, but that was in 2009, I think is the
So the
answer.
incident, this supposed incident happened when?
So he was,
Trying to get that time frame down.
so the allegation was made December of 2007. He was arrested sometime in February of 2008 and remained in custody from that point until his release, ultimately November 22nd, 2011. And then sometime in late 2009, this process started with her seeing doctors and the district attorney in 2010 taking up the torch of continuing to examine
And
it.
she was 14 years old at the time?
She was 14 years old at the time. Yes.
Thank you. Any other questions? Okay, so we can watch the video, please. I'm gonna stand up.
Feliz, feliz, finalmente se cierra una etapa de mi vida.
Atrás quedó la pesadilla de un hispano acusado falsamente por su hermana de haberla violado y encarcelado por ese delito.
Hoy la Fiscalía de San Diego anuncia que no presentará cargos contra Luis Galicia, quien esta tarde es ya un hombre libre.
Así es, para llegar a este día la familia Galicia vivió un calvario que duró casi 4 años.
Aquí la cronología de esta trágica pero asombrosa historia.
Todo inició cuando la familia Galicia visitó nuestros estudios.
Era el mes de agosto de 2010, impulsada por el arrepentimiento, llegó aquí la hermana de Luis Galicia, Araceli, una joven que en ese entonces tenía 15 años de edad y acompañada de su madre, nos confesó que había acusado falsamente a su hermano de haberla violado. Luis había sido enjuiciado en el 2009 por ese delito y estaba condenado a 15 años en prisión.
El 10 de noviembre del 2010, en Noticias Univisión San Diego, transmitimos un primer reportaje investigativo sobre el caso. Ahí mostramos nueva evidencia que favorecía la inocencia de Luis Galicia. Gracias a la investigación periodística de nuestro reportero Carlos González, la Fiscalía de San Diego aceptó indagar la nueva evidencia recolectada por Univisión San Diego. El reportaje demostró que Araceli era virgen y expertos corroboraron que no hubo violación por parte de su hermano. Además, revelamos a la luz pública fallas en la Agencia de Protección al Menor que manipularon a Araceli para que no cambiara su versión y siguiera inculpando a su hermano, a lo que la menor se rehusó.
Después de analizar la nueva evidencia, el 22 de noviembre del 2011, la Fiscalía de San Diego pidió al juez suspender la sentencia y se otorgó la libertad bajo palabra a Luis Galicia. Hoy hay una nueva historia que contar.
Así es, y aunque Luis Galicia estaba en libertad, existía la posibilidad de que se le presentaran cargos, pero hoy la Fiscalía de San Diego dio carpetazo final a este caso.
No encontró evidencias para volver a juzgar a este joven latino porque ya en este momento es un hombre completamente libre. Carlos González nos amplía.
Of all the evidence in this case, the people have decided to not pursue any new charges in this case.
Basados en las nuevas evidencias, la Fiscalía decidió no presentar cargos contra Luis Galicia, por lo que quedaba finalmente libre.
We are very excited that all of the hard work
La defensa indicó que todo el trabajo de varios años finalmente dio resultado.
Ya se acabó, mija. Over. Feliz, feliz, finalmente se cierra una etapa de mi vida. Ya agradecido con la cadena, agradecido con todos los que respondieron.
La familia creyó en él y nunca desmayó.
Pues la verdad muy agradecidos y demasiado contentos por la culminación que tuvo este caso.
Y gracias a ustedes que echaron esta gana, echaron muchos empeños, pusieron su empeño para empezar nuevamente del caso.
Gracias a Dios todo terminó ya. Después de 4 años podemos decir, terminó.
Contenta, alegre y todos los sentimientos así felices, buenos y a la vez libre.
Tal vez algo muy importante en todo esto es el hecho de que aprendimos algo cuando esta familia llegó a nosotros por ayuda, de que la justicia puede tardar, pero siempre llega. Según la fiscal del condado, no hay nada más importante que hacer lo correcto, que están en el negocio de hacer justicia y en este caso, la justicia prevaleció.
Este es un ejemplo a la vez de cómo el trabajo entre la comunidad, los medios de comunicación y la Fiscalía hemos llegado a un excelente resultado.
And where we receive additional information, and I want to say thank you to Univision for.
Según la fiscal, ellos actuaron cuando Univision llegó con nuevas evidencias para llegar en el caso de Luis Galicia a un justo final. La defensa pedirá se destruyan los registros de este caso para que esta pesadilla quede fuera por completo del futuro de Luis Galicia. La fiscalía coincide.
Yes, of course, yes.
Para Luis empieza una nueva vida.
Volver a la escuela, y reubicarme ya bien en la sociedad, buscar una carrera.
Carlos González, Noticias, Univisión San Diego.
Thank you very much.
You're very welcome. The Attorney General, we'll turn to you now.
Yes. Madam Chairwoman, members of the board, crimes that occur in the family home, like in this case, present unique challenges to law enforcement because by their nature, they often involve secrecy, power and control dynamics, divided loyalties, and many times love for the perpetrator. Due to these varied emotions, victims of child abuse and domestic violence are often reluctant to disclose the abuse. When it is disclosed, victims can face the new stress of prosecution and the family structure being impacted when the perpetrator is in jail. It is in the face of that tension between saving themselves from abuse or having the family continue to be impacted from prosecution of the perpetrator, both emotionally and sometimes financially. The victims of child abuse and domestic violence frequently recant allegations of the abuse. To experts who help treat these victims, as well as members of law enforcement, these dynamics are sadly common. Experts in domestic violence try to educate others about the cycle of violence, and experts at child abuse about child abuse accommodation syndrome. Due to the perpetuation of outmoded thinking, the victim recantation means that a victim was untruthful when they initially disclosed the abuse. These complicated family dynamics were fully present in this case and affected the behavior of the victims before, during, and after trial. Clearly, the hearing officer failed to appreciate the importance of the evidence of child sexual abuse accommodation syndrome presented at the hearing to this case because that evidence was not mentioned at all in the findings supporting the proposed decision. However, that evidence should not be ignored by this board. The facts in this case present an uncanny illustration of these complex and at times counterintuitive behaviors of victims of sexual abuse. The syndrome involves secrecy, helplessness, entrapment and accommodation, delayed and unconvincing disclosure, and retraction or recantation. All of those were present in this case. Here, after 6 years of abuse that she kept secret due to claimant's threats, the child victim first disclosed the abuse to a friend, minimizing what had happened. She then wrote a note to her mother asking what she would do if one of her sons was raping one of her daughters, and eventually disclosed to her mother. However, after taking her to a doctor in Mexico, Araceli's mother then dropped the subject and did nothing to protect her. It was at that point that Araceli ran away. Once out of the family home, Araceli disclosed the abuse to a school counselor, a detective, medical personnel, a forensic interviewer, her foster mother, another child in foster care, and a social worker. Nonetheless, after being in foster care for many months, seeing how upset her siblings were away from home, and being ignored and made to feel that she had caused all this trouble by her mother, Araceli recanted. Dr. Iraquiza, an expert in child abuse who testified at the hearing, said that 25% of all children who are brave enough to disclose abuse, which is very difficult in the first instance, later recant the allegation. He testified that the main correlation to that recantation is lack of maternal support. That fact was regrettably present here. Dr. Iraquiza further testified that false reports of child molestation are very uncommon or rare. The hearing officer also completely disregarded claimant's confession to molesting his sister, even though it had the semblance of veracity. Instead of wholesale admission of all he was accused of, claimant actually maintained his denial of parts of Araceli's disclosure, for example, that the abuse happened in Mexico, which cuts against the notion that his will was overcome by the detectives. Also, he provided details of the crime, the time frame, and the abuse itself. Finally, the confession also contained justifications and rationalizations for his behavior, that he'd been molested at age 6, and that he did not force Araceli, as she was the initiator. Providing excuses for criminal behavior belies an acknowledgement of wrongdoing that should not be dismissed out of hand heedlessly, especially when coupled with claimant's failure of memory about the interview on cross-examination at the hearing, followed by his impeccable memory about it on direct exam. Finally, the hearing officer failed to appreciate that the medical evidence in this case did not exonerate claimant. The medical personnel who were actually qualified to render medical opinions on child sexual abuse, a specialty, were Doctors Spencer, Tixon, and Sharash, and nurse practitioner Kathy Boyle, who evenly split between findings and no findings of abuse in this case. However, what they all agree on is that findings in non-acute cases like this are rare, with normal exams in 90 to 95% of cases of reported abuse. When this fact is combined with Dr. Iraquiza's testimony that false reports of sexual abuse by children are uncommon or rare, it is clear that a normal medical exam does not mean that abuse did not occur, and all the experts in this case have said, or would undoubtedly say, the same. The hearing officer's proposed decision finding that claimant is innocent by extension finds that Araceli lied. A witness's demeanor can be very useful in determining credibility. The following video is a short clip taken from the beginning of Araceli's forensic exam shortly after she ran away. Initially in the clip, Araceli is giving background information, and then she's asked to tell what happened. She begins answering that question by saying, quote, "Everything started when I was 6 years old. I was a happy little girl, and then one day I stayed with my brother."
Araceli, dime por qué viniste hoy.
Es que me llamaron y yo no sabía para qué y me dijeron, antes con la señora que me fue a recoger, me dijo que me iban a hacer una entrevista y tenía que contar todo y después, antes de eso me iban a hacer el chequeo para ver si estoy diciendo la verdad o no.
Sí, estás diciendo de la verdad.
Sí.
Ok, y dime lo que... Dime.
Todo lo que pasó. Todo empezó cuando yo tenía 6 años. Yo era una niña feliz. Pero un día me quedé con mi hermano. Se había ido, vivíamos en Tijuana y mi mamá se había ido a, no sé si a la plaza con mi tía y mis hermanos. Me quedé yo sola, estaba jugando en la cocina y que mi hermano estaba en la sala. Y luego que me dice, hey, ven, vamos a jugar. Y como yo era chiquita y necesitaba a alguien con quien jugar. Y le dije, está bien, pero luego él me empezó a jalar. Le dije, no, y luego dijo, pero vamos a jugar bien. Le dije, me jaló y luego me llevó al cuarto y no me acuerdo muy bien si me empujó en la cama o me dejó parada. Luego me empezó a sacar toda la ropa y se la quitó a él. Y ya luego me empezó a besar todo el cuerpo. Y luego metió su parte en mi parte. Yo estaba llorando y después de eso me dijo que si yo le decía a alguien que algo me podía pasar a mí o a mi familia. Por eso no conté nada en todos los 7 años, que tenía miedo de que le haga algo a mi familia.
Y tú me dijiste...
After breaking down and crying, Araceli went on to say that claimant, quote, put his part inside my part. I was crying, and after that he told me if I told anyone that something could happen to me or my family, That's why I did not say anything, because I was afraid he would do something to my family. The young girl breaking down in that video was not lying when she painfully and courageously admitted she was a victim of molestation for 6 years. The fact that she recanted this disclosure after 6 months of standing by it under family pressure does not mean she lied. To simply equate victim recantation with lying without considering Dr. Eric Hiz's testimony and the family dynamic in this case, as the hearing officer did, wholly disregards the psychology of victims of abuse and the difficulty in being the pivotal witness in a prosecution against a family member. I respectfully ask the board to deny this claim.
Are there any questions? I have one question. Was the note that was written by the daughter to her mother that you mentioned in your testimony, was that note part of the record? Was that admitted in the court?
I think it's part of the testimony from the trial, so it would be in the reporter's transcripts from the jury trial where a claimant was convicted. I don't know if the actual note was admitted as an exhibit in that jury trial.
If I may add, Chairperson, it was never found. It was an issue in the trial because there was no note that was ever produced. It was just the mention that there was a note. The whole idea that she had been taken to Mexico to have an examination that predated all of this by her mother for pregnancy was also debunked in the trial. There were no records that were ever produced. There were no pregnancy records that were ever produced. None of that came into the trial. The mention of them did, however.
Okay, thank you for that clarity. Okay.
If I may interrupt, there's another individual here in the audience to speak regarding this claim. I don't know when the board would like to hear from her. It's Christine Ward, and she's here from one of our victims groups in California.
Yes, I do have a speaker request form. So if Ms. Ward would like to come forward. You might want to, Deputy Attorney General, yes, thank you.
Good morning, Christine Ward with Crime Victims Action Alliance and ICANN. And as you know, we very, very rarely come out on claims like this. But this one was brought to our attention and we were asked to review it and consider coming and speaking today. And so I am here. This case really concerns us. This is obviously a very complicated case and a very unfortunate situation. I've been working with victims of trauma for almost 25 years. Part of my area of expertise was working with child sexual assault and child abuse victims for several years. In reading through this report, it really concerned me that there were many issues that were brought up that were disregarded by the hearing officer. One of which is information that was provided by nurse practitioner Kathy Boyle. Kathy Boyle is a national expert in sexual assault, child sexual assaults. Basically, in the field, working in the field of sexual assault victim support, we basically consider her her word the word of God. So it is concerning that this was completely disregarded. Additionally, there are a lot of issues that have been brought up in this case. The recanting of a victim, which especially at that age is more common than not. As a prosecutor, prosecutors know that sexual assault cases are the most difficult to prosecute because the lack of evidence and of recantation, especially when it is from abuse of a family member. Working with children the victim's age and being in the examination room with a victim and then coming out and having them speak with their parents, there were completely different personas. We had the victim who was able to open up and discuss with the examiner, but coming out and dealing with their family members, not wanting to be as open with them. So these cases are very complicated. There are a lot of concerns around this one. And personally, in my review of this, it was disturbing that the hearing officer found the claimant innocent, where I think that's very difficult to tell in this case. So I just wanted to offer my thoughts on this. We are, I'm just going to say it again, very, very concerned about the outcome of this case and the fact that we do believe that this young girl was a victim, is a victim, and that should never be forgotten. Thank you so much.
Thank you, Ms. Ward.
Madam Chairperson, if I may address some
Yes.
of that. With all due respect to Mrs. Hord and her organization, I'm very sympathetic to it. I'm sure that child sexual abuse is a very large issue. Obviously, she's devoted her entire life to it. However, I have devoted the last 3 years of my life to this case. I've taken 42 depositions in this case. I know this case inside and out, and every fact that happened. I've read the trial testimony over a dozen times. I know what evidence happened in this case and what evidence didn't happen in this case. To say that Kathy Boyle is the word of God is a little bit of an overstatement. She is a nurse who testified in this hearing that she knows more than any pediatrician and any gynecologist, including the district attorney's expert witnesses on SART exams, Dr. Premi Suresh, who testified she's performed over 1,000 of these exams and testified on behalf of the district attorney's office exclusively as an expert. She is the one who found that the report and the medical evidence in this particular case were false. The report of Dr. Spencer was false. Dr. Boyle, in the hearing that we had, I'm not sure Ms. Hord attended the hearing, but in the hearing that we had, she said, I've never examined Araceli. All I've ever done is looked at photographs of it, and she acknowledged that in looking at photographs, one can't really tell conclusively one way or another if these findings are there or not. So
I think you misstated that she was a doctor, just for the record to correct.
I'm sorry.
Nurse practitioner.
Nurse practitioner Boyle. So it isn't as if she came in here with some definitive evidence. The definitive evidence is the district attorney's expert witness, Dr. Premi Suresh. The interpretation of that evidence, as you can see by Bonnie Dumanis, who doesn't willingly get in front of the news media and get behind the release and the innocence of someone unless she truly believes it, is who's evaluated this evidence. Simply because there is a recanting in this case. Well, it's absolutely true that victims of sexual abuse recant. There's no question about that. We all understand that. But that doesn't mean that every single recantation isn't true. In this case, it wasn't true. The recantation, rather, was true. You can't just say in the absence of any medical finding that Luis Galicia is guilty. Simply because the victim recanted, Luis Galicia is guilty. The hearing officer in this case did the right thing. There was also a mention about a confession in this case, and I'd like to be clear about the confession in this case. The confession was thrown out of court. It was ruled inadmissible by Judge Weber in this case. The reason for it is because he denied ever touching his sister for over 4.5 hours. At the conclusion of the interview, the detective promised that the children, his siblings, who had been taken into Children Protective Custody 2 months earlier, would be returned to his mother if all he would do was acknowledge touching his sister. He then, after promising them they would return the children the next day, he said, I'll say whatever you want, I touched my sister. That confession never came into the criminal trial. It was completely ruled inadmissible by the judge. So to simply say there's a confession is a little misleading in this case.
So the details that the Deputy Attorney General talked about that came out in that confession, the details of the incident, the place, the time, the event, that was all dismissed?
Everything. The confession never came into the criminal trial. The only evidence that came into the criminal trial, at the point of the criminal trial, and Araceli didn't start recanting 6 months later. She started recanting 2 months later. The foster mother admitted in the criminal trial that she knew the recanting started 3 to 4 months later. The district attorney's office didn't admit the recanting for 8 months. So the official record shows a recanting 8 months later, but in the criminal trial, the foster mother said the recanting started in March or April, 3 to 4 months later. Araceli says, I started recanting in February, 2 months later. But by the time of the criminal trial, Araceli is vehemently saying, none of this happened, none of this happened, none of this happened. The only evidence that came in, and in fact impeached her testimony that nothing happened, was the report of Dr. Spencer. It was the only piece of physical evidence that came into this case. And as I've told the board, in this case, not only this report was under scrutiny, but 10 other reports by Dr. Spencer were also. She no longer is allowed to examine children for these SART exams. She doesn't perform this anymore. And I don't want to get into this case about Dr. Spencer, but the entirety of this suggests a man who was wrongfully convicted. The hearing officer did her due diligence. She listened to testimony, lengthy testimony, and I think reviewed over 1,000 pages of material that was sent to her. We request that the board respectively upholds her opinion.
Okay, thank you. Excuse me.
Yeah, I have
Any
one.
other questions?
Yeah, I have one question.
Yes.
Following up, you've spent a lot of time on this, you indicated
Yes.
before. Did you do a motion for, after listening to Bonnie DeManis, who I have a lot of respect for, my colleague, did you do a motion for factual innocence to get that from the courts and with Bonnie's support, et cetera?
The factual
prior to
innocence
coming
was
here?
not done in this case procedurally.
And why was that?
Well, there is a 1983 action that's going on in the civil courts, not surprisingly, which is the genesis of the 42 depositions that have been handled. It has, for whatever reason, that has been the vehicle we have been proceeding with, along with the parallel proceeding of making a claim before your board. It just hasn't been done. I don't have an explanation for it other than the case has been being pursued civilly. So there was no factual innocence that was done. It wasn't rejected, it just was never filed. We undertook to file a 1983 action and pursue it in this board, so.
Okay.
Any other questions?
I have no other questions.
No.
Okay, well, I will entertain a motion.
Should we do a motion first, or you want comments? Probably.
A motion and then comments.
Okay. I am going to move to oppose staff's recommendation at this time.
Is there a second to that motion? I'll second it. It's been moved and seconded to reject staff recommendation. Are there any comments to the motion?
Well, yeah, these cases are very complicated, as indicated by the presentation from the Attorney General's office and Ms. Ward. And recantation happens all the time, especially in family settings such as this. And it is a very difficult factual basis, especially when you have situations where there's no physical corroboration in areas of that sort with the medical profession, but then you have to take into consideration the mother and what she did and going to Mexico and the delay in that type of analysis. But then I weighed it heavily against, again, my colleague Bonnie DeManis and her assistant, who's a very good assistant. And I'm just very concerned that we don't have a finding of factual innocence here when we have I truly believe, a complicated matter with various issues, and it would have been nice to hear some experts. I know Kathy Boyles as well as an expert in this area, so it's just difficult for me to say that he's reached the level of preponderance of evidence to prove that he did not commit this. So I'm going to oppose staff's recommendation.
I would agree that this is a terribly complicated, very, very difficult case on many, many levels. It's very hard when we have only 27 pages of hearing recommendation to sort through the complications, the human complications, the facts of the case. It's very difficult to retry a case with 27 pages of a hearing officer's recommendation. I find in the 27 pages, it's very difficult for me to draw any conclusion from the medical officer's testimony. So I almost had to just disregard it because it's so difficult to sort through both the timing of the examinations, the evidence, how it was or how it wasn't reviewed by 3-4 doctors and a nurse practitioner. Anyway, difficult, very, very difficult. So I couldn't come to a conclusion, and I wanted to. Conclusion to support staff recommendation. But I just couldn't find, the evidence in 27 pages that led me to that. So are there any other comments or discussion on the motion that's before us?
I have none.
Okay, I will take a vote. All in favor?
Aye.
Aye. It's a unanimous vote to reject staff recommendation. Thank you very much.
Thank you. Thank you.
Okay, we will return back to the agenda. I'm going to take the executive officer's statement, which is item 3, again later in the proceedings. So we will turn to the consent agenda, which is item number 4. And Nicholas Wagner is going to present the item number 4, the consent agenda. Nicholas?
Good morning, Chairperson Batcher, members of the board. For the record, I'm Nicholas Wagner, and I will present the Government Claims Program agenda items. Item 4 is the Government Claims Consent Agenda. It consists of 293 claims. Before the board takes action on the consent agenda, item 54 for ComproMed, item 64 for Wahlberg Inc., item 277 for Pravares A. Chaudhry MD, and item 289 for David Reyes have been removed so that the claimants may appear in March. Additionally,
Excuse me, Nicholas, did you
Yes, I'm
say
sorry.
item 54? Was that the first one you listed?
yes,
Okay. Sorry.
no worries. Item number 46 for Fernando Serna has been removed so that the claimant may address the board today. With the exception of the removed claims, staff requests that the board approve the consent agenda.
Okay. Thank you very much. Do I have a motion to accept staff recommendation?
Second.
It's been moved and seconded to accept staff recommendation on the consent agenda with those items that Nicholas just spoke to removed. All in favor?
Aye.
Aye. Okay, thank you. So,
Item 46 is the claim of Fernando Sena. Mr. Sena requests compensation from the California Department of Transportation in the amount of $28,032 for a pay differential. Program staff recommends the claim be rejected. Representing himself is Mr. Serna. And then we have Peter View representing Caltrans, Christine Allison representing CalHR, and also Kim Erlach representing CalHR.
okay, could you please come forward to present your claim? And once seated, I'm going to ask each of you to introduce yourself, your name, and your title. We'll start at this end, go to the other. Thank you.
Good morning, I'm Kim Herlash, and I'm a Personnel Program Manager in the Personnel Services Branch at CalHR.
My name is Fernando Serna, and I'm a retired Caltrans supervisor.
Thank you.
Good morning, my name's Christine Allison, and I'm a Program Manager at CalHR.
Okay, thank you all. Mr. Serna, would you like to present your claim?
Yes. In 2001, I was promoted to a maintenance supervisor. And at that point, I wasn't informed that there was a claim form to be filled out for compensation for Class A pay, differential pay, because that form is strictly taken care of by the office clerical people and my immediate supervisor at the time. At that point, I promoted to management, and I never got any form to see that that was actually done. And so I went 13 years assuming that the state was paying me that differential pay. In 2013, I believe, my superintendent at that point did an audit on all his supervisors, which included, I think, 6 or 7 of us, and made note that there was $96 that was not paid, and that came out to the differential pay. The secretary at that point filed the California or Caltrans driver's license differential authorization, and she dated it back to 10/31 of 2001, and my superintendent signed it at that point. Later on, without me, I don't remember that they ever sent any forms to tell me, hey, we're going to start paying you back. All of a sudden, I started getting checks. And it's ridiculous how the accounting system for Caltrans expects someone like me to understand how they're paying you. So anyway, I ended up getting compensated for 3 years. I've been tested for alcohol and drug in the drug testing program as of March 13th, 2003. So I honored the mandated policy for the state maintenance department that I be tested for drug and alcohol as a maintenance supervisor. I honored it. I had no resistance to that. I just feel that I honored everything. I'm a government employee for 34 years. 3 of those I served my country, and I came back with an honorable discharge. I did 25 years with the state. I got out in June of last year. I did 5 years with the county of Fresno. I don't have anything really that I could have seen where I hadn't followed through with anything. But again, I have to reiterate, I had no clue that this was not being paid to me. My fault is that I did not check the state. I'm a loyal employee. I was dedicated because I promoted. The reason that I promoted was to be a good steward of the state, and I was. You know, the hot topics with the state is that we want to be stewards, we want to be ethical, we want to be moral in our decisions as managers. I feel that I did everything I had to do. I have check stubs here, and I always ask this of the state clerical people, is how come we don't have anything that tells us we are getting $96 pay for differential Class A pay? And they always just gave me one of these, don't worry about it, it's already included. Well, when I asked, show me, I never got an answer. And lo and behold, 13 years later, as a maintenance supervisor, I've never received that. I just don't think that it's ethically correct that the state deny me the money that they mandated I own up to. I owned up to it for 13 years. They gave me back 3 years of compensation, if I'm not mistaken. What do you call that? You guys know better than I do. The code says that I'm entitled to up to 1 year, but yet they paid me for 3. So if they can pay me for 3 and I'm only supposed to get 1, why can't they pay me for the rest? I just feel that this is not fair. It's not ethical. Ethical, ethical, ethical. The state wants me to be ethical, responsible, dedicated. I was. Now, why isn't the state being ethical about their payment to me after I followed everything? Not knowing this, I just don't quite understand.
Okay.
again, the question for me is, how can the state do something unethical like this? It was my right to get paid for it because they mandated it to me. I didn't ask to get a Class A license. I was held above the standard because I had that Class A. And as a supervisor, I had all my crews maintain ethical standards and stewardship. In my career, I was asked multiple times to figure out ways to be a steward of the state, and keep the ethics up, and try to maintain morale.
Right.
But when we go through situations with the state that can't give you answers, and because of whatever reason, they never can come up with the right answer, and they're a bigger entity than I am, it's easy to just say, hey, blow him off. He's gotten paid 3 years. Why should we pay him anymore? Ethically, I believe that's incorrect. The state has been unethical with me, and I've done nothing to deserve that.
Okay. Mr. Cerna, thank you very much. Mr. Wu from Caltrans, would you like to present?
Yes, I think there's a little confusion going on because...
Well, sir, I think you need to be at the mic so those who are watching...
I believe there's a
outside the
little
room
bit
here.
of confusion because he's describing $96 in differential Class A pay, but if you look at his request for $28,032, that's calculated at $192 for 12 years and 2 months, which is the period from October 2001 until December 2013. It's actually the 192 is the commercial driver's license differential. He's not missing money because he was promoted to the maintenance supervisor. It claims he's missing money because he didn't get the CDL differential. And the CDL is not based upon him being a supervisor. A wide variety of Caltrans employees are eligible for the CDL. It just happens to be if you're a supervisor, your compensation per month is $192. If you're a different position, it's less. He, as a supervisor, is not automatically eligible for the CDL. You don't get it as a matter of course. You are required to fill out a form. The form is PM0016. You must be approved by your immediate supervisor. You must be approved by the Office of Drug and Alcohol Programs, and you must be approved by the Division of Human Resources. You are also required to pass a federal drug test. Mr. Cerna did not apply for this differential until December 2013. Therefore, he is not legally entitled to the differential prior to that
How would
date.
he know to apply? How does the process work? How does the process inform someone who has that they can have the differential? Does their supervisor tell them? Is there a piece of paper that is sent to them? Does the union talk to them? How does that happen?
I am not actually familiar with the process. I'm not 100% sure how that process works, which is why I believe that the recommendation where you deny today but allow him to sue civilly is the appropriate course, because his rights are not being hurt in a sense, because he is allowed to pursue his civil complaint.
It sounds like
against-
some affirmative thing has to happen by the personnel, by the employee. And if you're not aware of that form, you don't have it, it's not sent to you, your HR person doesn't let you know, your union rep doesn't let you know, how do you know?
Well, that's an issue I believe that's appropriate for the discovery process, because I don't know what he knows, it's possible that he was given this information, he didn't do anything.
Well,
He
maybe
could
somebody
say
from
today-
Cal HR can help us with
He
that.
could say today, oh, I didn't receive it, but that's a process which will be decided.
Okay. Mr. Cerna, what is that you're holding out?
This is the authorization form, which has no place for my signature. My RAO.
That's the form that your supervisor gave you that alerted you to the fact that you could
And this
apply for
form
the
was supposed
differential?
to have been signed by my immediate supervisor at the point of my transition from rank and file to management. And
Who signed that form? Somebody from Caltrans, your
Carlos Lamelli, which was my immediate
What's
supervisor.
the date on that form?
He signed it on 12/23/2013. My RAO went back in the records and found the date that I was effectively promoted and should have been.
That date?
No, the date that she went back to was 10/31/2001. That was my point of promotion. And because I moved from rank and file,
But you didn't get a form in 2001?
Absolutely not.
The first time you got a form was when, after the audit?
after the
And they
audit,
found that you hadn't
Yes,
had the
ma'am.
differential pay?
yes,
Okay.
ma'am.
Trying to figure out this process.
Again, I'd like to point out that the amount that's in dispute is not based upon his promotion to the maintenance supervisor position. It's based upon the commercial driver's license differential. That form is PM 0016.
Yeah, but the question was, how does anybody know that that form exists? And how does an employee who may be able to get that differential pay, how do they know that that form exists? That's the question.
If I may, as a supervisor, I've had, the process is when you're rank and file and you're not an operator, in order to promote, 6 months after you promote, you're required to have the Class A. At that point, when you get the Class A, I'm not mistaken, this form came to me for all the employees that had gone through the process, and I approved it as the immediate supervisor. That's why my immediate supervisor was my superintendent at this point. The superintendent that when I promoted has been retired for years. The RAO that filed this has retired.
Right.
So again, you are correct. How did I know
Right.
that this form?
Maybe we'll listen to the Kelly.
And if I may, one more?
What?
The 28,000, I'm not asking for that, because I've gotten paid for 3 years of payment. So I don't see where, again, I don't know his numbers. I was always under the impression it was only $96. He came up with another figure. Maybe that's correct, I don't know.
Yeah. Thank you. Mr. Vu, do you have anything additional to say?
I just want to say that the 192 is what's on his VCGCB claim form.
Okay,
Definitely puts-
so let me turn, if I may now, to CalHR, because I'm confused about process.
Yeah.
Maybe you can help us with that. And maybe you can help us with the 1 year, the 3 years, not the entire amount,
Right.
that going back to 2001.
Good morning.
And I'm sorry, restate your name, please.
Sure,
for the
sure.
record.
Christine Allison from CalHR. Unfortunately, CalHR is not able to speak to the process that Caltrans employees are required to go through in order to secure the pay diff. We can explain what the pay differential states, what the criteria is when employees may be eligible, but beyond that, we're not able to speak to how Caltrans processes pay differentials internally.
Okay, generally, how should pay diffs be processed?
Unfortunately, I believe that they may be done differently depending on the pay diff, the requirements of the pay diff, and also depending on the department and their internal processes. I'm not aware of the form that was identified, and it's clearly an internal form that is established by Caltrans, and that process would be defined by them as well. But CalHR's position is that the state's liability related to this claim is 1 year, and
why
this
is that?
why, based on the statute of limitations in Government Code 911.2, as well as Government Code 19815.8, that would limit the statute to 1 year.
So why would Caltrans paid him 3 years then?
I can't speak to that.
Can you speak to that, Mr. Vu?
First, let me just establish, I'm an attorney at Caltrans. I was speaking with CalHR. They gave me a bird's eye view of what was going on in this case. Government Code Section 19818.16 allows the department to give compensation to employees outside their scope of their performance duties, and they allow for a period of 1 year. I was told by Caltrans HR that it's a Caltrans HR policy that they sometimes for employees will go to 3 years. I think that's just a generosity issue for Caltrans.
I don't think. Yeah, it's illegal to give people a gift to public funds. I mean, we would like to be generous, obviously, but that is illegal, so.
I was
can't do
told
that.
that their policy is 1 to 3 years.
Okay. Do they have a written policy? Does your HR office have a written policy?
I don't know if it's a written policy. This is verbally.
Okay, we need, I mean, proper work in state government means, especially if you're talking about people's compensation, there needs to be a written policy. I am really confused about this. I'm confused about the math, even if we tried to go forward with what's being asked.
I agree. Is it possible to go back and have them work that out and the numbers, and let's find out this process? I mean,
Sure. If you look at the right up on the agenda, if you look down the analysis, as I understand it, Nick's division did a review of what actually would be owed to Mr. Cerna, and they came up with a $20,928 amount.
And that's based on the one,
It's a new figure to me. I thought it was 96, madam.
Nick, do you have any knowledge on the?
Yes, it's based on it's a calculation of the pay differential. I believe it's at the 192 for the period of time excluding the 3 years for which Mr. Cerna was compensated.
That's incorrect. It's 192 multiplied by 12 years and 2 months. And that 12 years and 2 months is dated from October 2001 until December 2013.
Nick, what was your time frame of that calculation? Do you remember? What staff's, what's different from what Mr. Wu is saying?
I apologize. I don't have all the arithmetic for the calculation in front of me.
I think we need that.
All due respect to my chief counsel, I really think we need to be absolutely clear on the arithmetic here.
Yeah.
So I think we need to take this back and work it up again with all the pertinent facts.
I mean, even Mr. Cerna's not clear on it, so in fairness to him, he needs to be clear on what is being proposed, and we need to be clear on what's being proposed. So I'd like to defer this to staff, or refer this back to staff and defer it to the next.
We'll recalendar.
The next meeting. Mr. Cerna, I'm sorry for this confusion. We're gonna make it clear. And we'll ask you to come, if you wish, to come before the board, the next board meeting we have.
Of course.
And staff will work on this so we have clarity.
So the confusion is the dollar amount. Is that
Right
what you're
now it
saying?
is, and the time frame too.
But not the entitlement
Well,
of
we
the
don't
date.
know. We have to, we'll look at that. We're trying to look at the entire picture. I don't want to presuppose, nor can I, a vote on the board, so I can't do that. But we want to be clear on what it is we are voting on, and we're not clear on that right now. And I want to be clear on the policy that exists at Caltrans too. I don't want people to suppose that there is a policy. I want to know the policy of where how paid diffs are actually paid, and what form is handed to a supervisor, and what is that process, and what policy chases that process, informs that process, I should say.
At the next hearing, I will request to have Caltrans HR come with me.
And if you find you don't have a policy, in all due respect, I suggest you have one, or they have one.
Will they have this information for you at that point?
We will let staff, Mr.
Yes.
Cerna, work on this. We need clarity on many levels. Okay? Thank you all very much for your time. I appreciate it. Okay. All right. That takes us to item number 5. Nick, I believe. Would you like to brief us on item number 5?
Item 5 is the claim of Metropolitan Van and Storage.
Wait a minute. Do we need to have a motion on that? I'm sorry. To refer
I
it back
think
to
you can
staff?
just direct staff to bring it back.
Okay, thank you. Sorry, Nick. Yes, you are, sir. Until staff will be in contact with you. Thank you, sir.
Thank you.
Item 5 is the claim of Metropolitan Van and Storage. Metropolitan Van and Storage requests compensation from the California Department of Motor Vehicles in the amount of $9,428.94 for unpaid invoices. Program staff recommends that the claim be rejected because it raises complex issues of fact and law beyond the scope of analysis and interpretation typically undertaken by the board. Representing Metro Van and Storage is Mr. Dave Smart, and representing the Department of Motor Vehicles, we have Rosemary Ruggiero and Allison Stanek.
Okay, could the three of you come forward, please? Try and sit in a, I know it, sorry, we kind of make sure the mic when you speak is available to you. Thank you. Okay, Mr. Smart, would you like to present?
Sure, I'm not sure if I know how much prefacing or setting up the scenario, but essentially we're claiming compensation for one compensation item, line item, per the contract and the bid therefore. And that item is specifically compensation for travel, our employee travel compensation to and from particular sites. And the travel item becomes compensatory as the item reads. Travel compensation will only apply for travel to work sites that are greater than 50 miles away from the awarded contractors or subcontractors, if applicable, parenthetically, base of operations. So again, greater than 50 miles away from the awarded contractors or subcontractors' base of operations, whichever is closest to the work site. We did not specify subcontractors in our bid. We did not use subcontractors. Therefore, it should simply read greater than 50 miles away from the awarded contractor's base of operations. Now, base of operations is actually, according to Roget's thesaurus, a center of operations, a command post, a nerve center, a headquarters, a main office, company headquarters, main office, base, central station, or headquarters.
Excuse me, sir, I'm concerned about time. Did you have a contract?
Yes,
Were these details spelled out in the contract?
they were. But after we provided several service request fulfillments based on jobs that did in fact pay this stipend for travel, at some point they chose not to compensate per the contract, but chose to use, instead of base of operations, something similar to nearest office capable of providing those services. So again, they're saying they didn't want to pay that compensation because we had an office that was closer than our headquarters could have provided.
But they
the service.
did pay some of the invoices previous to the change, is that correct?
Right, and so why they
Per the
stopped-
contract?
Per the contract.
Okay.
Sure. And so why they stopped is beyond me.
Okay.
Now, it's interesting to note that I mentioned the language in the contract and the bid therefore, where they use the operative phrase base of operations. In the next bid cycle, they changed the language for that 50-mile stipulation to read "50 miles away from the contractor or their authorized subcontractors, if applicable, nearest office that is capable of providing the required services." So that was
But that was a new bid, right?
subsequent to the.
Right, that's a separate contract. new bid.
Right.
Okay.
So,
Let me turn to DMV now. I think I understand the facts. Could you please address the board?
Good morning, Madam Chairwoman and members of the board. My name is Rosemary Ruggiero. I'm a senior staff counsel, attorney 3 at DMV Legal.
Good morning. My name is Allison Stanek. I'm an associate government program analyst with the Department of Motor Vehicles non-IT contracts unit.
Okay.
Madam Chairperson, first, we respectfully ask that you deny or reject this claim. First, there's a large amount of evidence in the bid, the contracts and supporting documents that heavily weighs against the claim. The base of operations in these in this contract was West Sacramento. We were not given invoices that broke out the mileage to us. There was then just the demand for this payment. Second, DMV, when we had this dispute, asked the contractor for documents and evidence to show us his side of the story, and he did not make that forthcoming, did not provide us access, and did not give us the evidence. Other locations that are listed that he claimed were outside of the 50-mile range were not the base of operations in which he listed.
Which he listed where? In the contract?
Various
or
locations.
In
such
the
as-
invoices that he did submit?
But he did not, he was supposed to list out the mileage when he asked in those invoices, and those were never listed. And that's what the contract required, the language of the contract.
May I comment on that?
Quickly.
Yes, again, the contract did not ask for mileage, it asked for the time that it took to make that travel.
We'd
on
have to
those
see the
jobs.
contract to understand this.
Recommending the issues are complex and
Right,
should be
right,
handled
yeah,
in-
I think that's probably right. There's a complexity with this case. There's evidence that we don't have the contract, your invoices, the time frame, your understanding, so, I'm going to.
I'll move staff's recommendation.
Well, okay. It's been moved and seconded to accept staff's recommendation, which is a recommendation that this raises complex issues of fact and law beyond the scope and analysis that this board normally and typically undertakes. So all in favor of the motion?
Aye.
Aye. Thank you, sir. Staff can advise you what your next steps are. Thank you very much.
Thank you.
Thank you.
Thank you.
Yes. Board Member Ramos has to depart at this time. We still
very much.
have a quorum, so we will continue. Thank you very much.
Thank you, staff.
Okay, so we will move on now to item number 6. Nicholas, would you please brief us on this item?
Item number 6 is the claim of Melanie Ripley. Ms. Ripley seeks compensation from the California Employment Development Department in the amount of $14,470.91 for a lien placed on her real property. Program staff recommends that the claim be allowed under authority of Government Code Section 965, which is agency pay. Ms. Ripley is here she will be represented by her counsel, Stephen Stapleton, and then we have a number of representatives from the Employment Development Department that I will allow to introduce themselves.
Okay, I see everybody's lined up. Please take a seat. And when you do introduce yourself, try and get to a mic to do so. I'm sorry, we only have 3 mics.
I'm Stephen R. Stapleton with the Strategic Legal Group, and I'm a paralegal with the firm representing Melanie Ripley here.
Okay. And you are Ms. Ripley.
I'm Melanie Ripley.
Okay, thank you.
Shanae Buffington, attorney with the Employment Development Department.
Okay.
Kaylee Chris from Employment Development Department.
Angel McCullough, manager at EDD, Employment Development Department.
Okay, either Ms. Ripley or your counsel.
Your staff has done such a wonderful job, and I'm very cognizant of your time restrictions here. Would you like me to go through my 3-minute factual recitation so you kind of know what's going on? Or are you familiar enough that I should just skip to the pitch?
Skip to the pitch.
Basically, Allison Ripley, Melanie's ex-husband, is the villain in this piece. He originally tried to steal community resources from her, and when that didn't work, he had to compensate her. After their divorce and his sex change operation, Allison Ripley then ripped off 5 years later, or 3 or 5 years later, the Employment Compensation Board. And he has never, frankly, been punished for either of those attempts at fraud. And we're suggesting that the interests of the state of California are best served not by punishing by punishing Melanie Ripley, who had nothing to do with the unemployment compensation fraud, did not benefit from it, never received child support from Allison Ripley, who did nothing wrong and lived her life completely unawares of this was going on, and allow Allison Ripley to go scot-free, because that's what's happening here. She's paying the bill that he created, or she created, and she's getting off scot-free. And we're saying the interests of California are to punish the perpetrator. And due to the paperwork error, that her deed was not recorded. And she sent it to her divorce attorney. She did everything that she thought she needed to do. It simply didn't get changed. And so the lien was properly, and we don't dispute that, attached to a piece of property in a race notice state that said he was still on the title. He wasn't, but we're a race notice state, so you had every right to do what the unemployment board had every right to do what they did. But we're saying, in equity, this is wrong, that the state of California's interest in punishing perpetrators and extracting the fine and the money gained from the actual person who got it is outweighed by simply getting the money back from anyone who happens to have it. And so that's our pitch.
Okay, thank you. Turning to EDD, please.
Yes, Madam Chairperson. I provided some information regarding our benefit overpayment collection process to Mr. Wagner. I don't know if the.
Yes, we have that.
Thank you. So in this particular case, I'll quickly go through the facts. In overpayment, Mr. Ripley received unemployment benefits in 2011. He was notified.
Objection, she's now a woman, and I think
I
we
apologize.
have to.
We'll get to that. I mean, let her just proceed if you don't mind. I think we got that earlier. Thank you.
Okay.
Allison Ripley received unemployment compensation in 2011, and in October of 2011, Allison Ripley was notified that he had been overpaid in UI, unemployment insurance benefits. In June 29, 2012, the EDD filed summary judgment as well as an abstract of judgment, which was filed with the San Diego County Recorder's Office. The EDD contends that the deed is not a valid transmutation of community property to separate property as pursuant to Family Code Section 852. Family Code Section 852 provides that a transmutation of real property is not valid unless it is made in writing by an express declaration that it is made, joined in, consented to, or accepted by the spouse whose interest in the property is adversely affected. Second, the law is pretty clear that unrecorded deeds are not effective to third parties that don't have notice. Family Code Section 852B provides a transmutation of real property is not effective as to third parties without notice thereof unless recorded. Family Code Section 1502B provides the recording or non-recording of a premarital agreement or other marital property agreement has the same effect as recording or non-recording of a grant of real property. Civil Code Section 1217 provides an unrecorded instrument is valid between the parties who entered into contract and to those who have notice. When the EDD filed its summary judgment and abstract of judgment with the court and county recorder's office, the EDD did not designate that the residence in issue be liened. We simply filed the abstract of judgment with the county recorder's office, San Diego County recorder's office, because that's where Allison Ripley resided at the time, and thereafter the lien was placed on any property that was owned by Allison Ripley. So with
Okay.
that, we respectfully request that the claim be denied.
Okay, thank you. Are there any questions, Rick?
No.
I will entertain a motion.
I'll move staff recommendation.
I will second staff recommendation. All in favor? Aye.
Aye.
Thank you very much. Okay.
Thank you so much. We appreciate it.
Thank you, Mrs. Ripley. Okay, now we are moving back to item number 3, which,
I can defer my report until next month if that would assist the board in completing their business in closed session.
I would appreciate that if
I'd
that's
be happy
okay.
to do that.
Okay, thank you. All right, then we're going to be moving on to closed session, I think is where we are. Yes, so this closes, we already took up item number 8 earlier, as you know, so we're moving on to the Victim Compensation Program. This closes the Government Claims Program portion of our meeting. We will now move to the Victim Compensation Program portion. The board will convene in a closed session pursuant to Government Code 11126C3 to discuss numbers 1 through 71 of the Victim Compensation Program.